Hello and welcome to Absolute Trust Talk. This is another live version of our podcast. I'm Kirsten Howe, your host, and today your only presenter. Today we're going to be talking about trustee and executor do's and don'ts, which is kind of a nice way of saying we'll talk about some mistakes that trustees and executors commonly make and how to avoid making those mistakes. And we're going to talk about just a few of the mistakes that we tend to see. I can't cover in a short period of time all of the mistakes I've seen in my career, but some of the common ones we'll cover, and hopefully that will help those of you out there who either are trustees or executors or who know that you're going to be someday a trustee or executor. It'll help you maybe avoid making some mistakes. As always, we are recording this, so if you don't get a chance to see the whole thing live, you can always watch the video on our website. Okay, so let's get started. Trustee and executor do's and don'ts. And I want to start out by saying the mistakes that I'm pointing out are being made out of a lack of awareness or knowledge. They're not because people are bad or trying to do the wrong thing. In my experience, the trustees and executors are always trying very hard to do the right thing. They just don't always know. So we're going to talk about a few categories, and I'll name them and then I'll go back and explain them. My category number one is fiduciary mistakes. Number two is record-keeping mistakes. And the last category I'm going to talk about is protect and preserve mistakes. Now, I'll explain that because that doesn't mean anything to you all right now. So the fiduciary, what the heck does that mean? A fiduciary, what is a fiduciary? A fiduciary is someone who has a fiduciary duty to another person or other people. So a fiduciary duty is the duty to do what's in someone else's best interests ahead of your own best interests. For example, attorneys have fiduciary duties to their clients. When a client hires me, now I have a duty to do what's in my client's best interests, even if it's not what's best for me. That's the deal. That's what attorneys have to do. Trustees and executors also have fiduciary duties to the other beneficiaries of the trust or of the will. And that's great, and they try real hard to do their job and honor their fiduciary duties. One of the problems that we see is that oftentimes the trustee is also a beneficiary. And so they can be in a situation where they have this fiduciary duty to do what's in the best interest of all of the beneficiaries, but it might be unclear to them that that's different from what's in their own personal best interest, and they get a little confused. So I'm going to give you an example. Let's say we have an estate or a trust with three assets: a house, a bank account, and an investment account. And miraculously, each of these three assets is worth $100,000. And we have three beneficiaries, and they're supposed to be given equal inheritances according to the terms of our will or our trust. And our trustee or our executor is one of those beneficiaries. So the executor trustee says, well, I would really like to have a rental property. I think it would be cool to have rental income. I want to take the house, and I'll give the other two beneficiaries the cash and the investments. Well, we can't do that. Even though they're of equal value, they are not necessarily equal. So the trustee is not allowed to, cherry pick the assets and pick the best for herself. They have to work it out so that it's fair to everyone, because the trustee has a duty to everyone. Another example of this is in the area of what we call self-dealing. So if the trustee is in a situation where the trustee could be entering into a transaction with himself. So here's an example that will make more sense. Let's say my same example, there's a house, a bank account, brokerage account, and the house needs to be sold, and that's part of the trustee's job. And the trustee happens to be a real estate agent. Now, the house needs to be sold, so we need to hire a real estate agent to list it and sell it for us. So somebody is going to get paid a commission on that sale, and our trustee would like for that to be himself, because he's a real estate agent. He'd like that commission. We have to be very careful about that, because remember, the trustee's job is to do what's in the best interest of all of the beneficiaries. And so let's say in my example, the house is located in Los Angeles, and our trustee's real estate practice is located in Lafayette. Now, certainly the trustee could sell it. The trustee is a licensed real estate agent. But is the trustee really the best agent to sell a house in a market that the trustee doesn't know at all? Probably not. So we have to be careful with those kinds of things. The trustee's primary job is to do what's in the best interest of all of the beneficiaries. So that would mean hiring the best agent, not necessarily the one that will get money to the trustee. Okay, so those are examples of situations where the trustee's a little confused about their fiduciary duty, and it's understandable. It's kind of hard to keep those things straight. The second category of do's and don'ts I want to talk to you about is record keeping, and this is really a big one. It causes a lot of problems for our trustees and our executors. It's hard. Being a trustee and being an executor is a hard job. It's not easy. And at the end of the job, when you are done doing everything and you're just about ready to distribute all the inheritances out to the beneficiaries, you have to normally provide the beneficiaries with an accounting. And an accounting is like the financial story of what you've been doing for the last 6 months or 8 months, 10 months, maybe longer if it's a probate. You know, you're telling the beneficiaries, okay, when I took this job, this is what I had, these are the assets I had. And then I had to spend money on a CPA, I had to spend money on an attorney, I had to pay a gardener to keep the house going until we could sell it, you know, all these things. And some of the assets actually earned income. I earned interest on the bank accounts, I earned dividends on the stocks. And now that I'm ready to give you your inheritance, this is what's left. And so you have to report all of that. That's your accounting. And it's got to be presented in a way that is understandable by the beneficiary. So you can't just throw all your receipts and your canceled checks in a shoebox and hand it to them. No, it has to be organized. It's spreadsheets and statements. And so you've got to stay organized. And I'm going to just say you have to keep it current. So it's kind of analogous to when you were in junior high and you had a science project. You had to do a science project, and it wasn't due for 3 months. Well, you have to work on that science project for the entire 3 months. You can't possibly do it the night before it's due. You've got to work steadily away at it. So our record keeping for our trustees and our executors has to be kept current, because it's a huge job. And if you don't write things down as you go, you don't enter things into your spreadsheet as you go, it's going to be nearly impossible at the end to reconstruct it all and get it right. So this is one thing where our trustees and executors have a lot of trouble, is they'll do something like a check comes in. So sometimes the decedent paid something in advance and now they get a refund because they have died. So a check comes in and the trustee deposits it into the bank account. Well, now there's no record of what that was for. It's just showing up in the bank account. So, write it down. I got a check. This is what it was for. Or even better yet, make a photocopy of all the checks that come in. So keeping really good records, keeping them up to date is really, really important. And the last thing I want to say about record keeping, our trustees are entitled to be compensated for their time. The trustee and the executor job, they're hard jobs. They take a lot of time, and most of my clients are surprised really at how much time it takes. They had no idea when they took the job that it was going to take so much time. So I always tell my trustees, keep track of your time You got to keep a timesheet just like a lawyer does. Every time you work on the case, you write it down, you write the date, you write how much time you spent and exactly what you were doing. At the end, when it's time to prepare your accounting, and even though you didn't think you were going to take any compensation in the beginning when you started out, but now when you look back at it and you realize, wow, that was a lot of work. I really should get compensated. If you have kept track of your time, it's much easier to figure out what would be fair compensation. So my point being, just keep track of your time. You might actually need to use it. You might not, and if not, that's fine. You can throw those timesheets away, but keep track of your time. And first and foremost, keep accurate, clear, and up-to-date records all through the time that you're serving as trustee or executor. The last category of trustee do's and don'ts, executor do's and don'ts, I call it protect and preserve. So the executor, the trustee, they are responsible for this estate, for this collection of assets, whatever they are. It might be a house, it might be a car, it might be a bank account. They're responsible for it, and they have to take care of it until they give it to the beneficiaries. So taking care of it means, first of all, don't make distributions until you are supposed to make distributions. And my advice for you is, if you're thinking about making a distribution, talk to your attorney first. So in a probate, we can't make distributions until the judge orders it. So you definitely don't want to do that in a probate. In a trust, it's not as critical, but you don't want to make a mistake. So talk to your attorney before you make a distribution. I'm going to give you an example, and this is kind of a common theme that we see. We've got, let's say, mother died, and we have her trust, and her trust says, I leave everything equally to my 3 children. And one of the assets of mom's estate is her car, and it's a little old lady car. It's not new. It's got low mileage, but it's not a car that you would choose to purchase or to drive. And so each of the 3 kids has a car, and they don't need that car. They don't want that car. And so the trustee wants to give it to one of the grandchildren. Well, the grandchildren are not mentioned in the trust. They are not beneficiaries. So the trustee can't do that. But if the trustee goes ahead and does that, then the law firm has to go back and fix that and document that and get everybody's consent and make it all okay. So before you make a distribution, talk to your attorney. And if you're in a probate situation, for sure, don't make any distributions without permission. Second thing under protect and preserve is you've got to avoid mixing assets together. We call that commingling. So open a separate bank account for the estate or for the trust, and don't put anything else into that account. Don't pay anything out of that account except for the expenses of the trust or the estate. Sometimes we see trustees mixing the estate money with their own into their own checking account, and they figure, well, I'm writing all these checks myself anyway. What difference does it make if it's all coming out of one account? We'll figure it out. It's just there's so much extra work when you mix things together. So don't commingle. My last do/don't under the category protect and preserve is the assets themselves have got to be kept safe. They got to be protected from harm or injury. So, for example, if your trust or your estate owns real estate, it owns a residence, you have to make sure that the homeowner's insurance is kept up to date. It gets paid. You actually have insurance. If it's a rental property, that's a different kind of insurance, but you have to have it. If it's a vehicle, same thing. You have to have automobile insurance. And in that vein, I'm going to go back to my grandchild with the car scenario. If you have in your trust or in your estate a vehicle, you are now responsible for that vehicle until you transfer ownership of it to somebody else. So while you are the owner of that vehicle, number one, make sure you have insurance on it, but number two, don't let anybody else drive it. Because if that person gets into an accident, even if eventually that vehicle is going to be given to that grandchild, don't let them drive the vehicle until they actually own it. If the grandchild's driving it and they get in an accident and you still own the car, you're going to be named in that lawsuit, and you don't want that. That is not a good thing in terms of upholding your fiduciary duty to the other beneficiaries. So make sure that you keep control of vehicles and anything else like that where somebody could cause damage to the estate or could sue you. All right, so we've covered a few kind of large categories of do's and don'ts, mistakes that we see our clients making. Hopefully that will help you. That'll help you avoid making mistakes. We are here to help you too. If you are an executor or a trustee, we are here to be your attorney. All you have to do is get in touch with us. You can do that by going to absolutetrustcounsel.com, and there's a calendaring feature there. You schedule a very brief discovery call with Emily, and she'll talk to you just to make sure that we're the right law firm for you. Sometimes people call us asking us to do things that we don't do, but once we determine that, she'll get you on the calendar and we'll have a meeting, you and I, and we'll figure out what needs to happen from there. And those initial meetings are complimentary. It's just a discovery. So if there's anything we can help you with, we would be honored to do that. Now, I said I would answer questions at the end, so I'm going to turn to the questions. Okay, here we go. If you're in charge of an estate, can you sell assets? For example, real estate. Okay, so the answer is generally yes, but you have to be careful when you're doing that. So the question used the word estate. So to me that means it's a probate, but I might be being too specific. In a probate, you can sell real estate if you have the authority. Some executors don't have that authority, and always in a probate, you have to check and let the beneficiaries know that you're selling the real estate. So in a probate, you got to be careful, but generally speaking, you can. With a trust, you can sell the real estate. That's not an issue. Another question. What if the trust has only a house and one child wants it, but the other child wants cash? Does it have to be sold? Not necessarily. There are ways to make that happen. It could be that the child who wants the house gives money to the child who wants cash, gives his own money to the child who wants cash, and then they can work it out. So it really depends, and it means that there has to be a conversation between the beneficiaries and the executor or the trustee to figure out how we can make this work so that everybody's happy. And we stay out of litigation. That's the primary goal. Okay. If all the other beneficiaries agree that the trustee can have a certain asset, such as a house, is that okay? These house questions come up a lot. If all the other beneficiaries agree, yeah, so like in my initial scenario, we have a house, we have a bank account, we have an investment account. If the trustee wants the house and everybody else is fine with that, then that works just fine. My recommendation is that you document that agreement, that this is what we all agreed, and that's why we're doing this in a maybe somewhat lopsided way, but everybody's happy. Just document that. Okay, what happens if the trustee doesn't give the beneficiaries an accounting? That's unfortunate. Well, the beneficiaries need to ask for an accounting, and if the trustee still doesn't give an accounting, you can go to the probate court, you file a petition asking for an accounting, and the judge will order the trustee to provide you with an accounting. And that's pretty standard. The trustee has to provide an accounting, so it won't be smart for the trustee to let you go to court. They're going to end up getting that order. They're going to end up having to do the accounting, so they might as well give it to you without spending a whole lot of money going to court. But that's how you do it. You file a petition in the probate court. All right. Well, I think we're at the end of the questions, and so thank you very much for being here today with me. Remember, you can always reach out to us, absolutetrustcounsel.com. We're going to do another live event in a couple of weeks. I hope you'll be here for that, and in the meantime, I look forward to connecting with you next time.